collaborations can be dangerous. Is this commercially sensible to patent, or is this actually just a waste of time?
That could be devastating for the entire team, really.
Everyone's got to have it in their minds that you keep things stumm.
You know, having more than one patent can actually be really great.
Keep in mind the commercial goals that you're aiming for and work on that basis.
Hello and welcome. I'm Robert Games, Managing Director of Albright IP. Welcome to our podcast, Figure One, an IP Conversation. Today, I'm joined by Will Doherty, a British and European patent attorney with a particular focus on supporting SMEs and sole inventors. We'll be discussing the practical steps involved in invention capture, what it is, why it matters, and how to do it well. Will, thank you for joining me.
Thanks for having me.
Great. Let's begin with the basics. When we talk about invention capture, what exactly do we mean by that?
So invention capture is the process of documenting what you're doing. So if you think you might be part of a research and development team, what you're looking to do is put your ideas onto paper so that they can be kept, evaluated, and a determination as to commercial importance can be made by management, board, whoever. But it's about getting those ideas written down and documented in some form.
Okay, so this is not about filing patents. It's basically about creating a system for recognizing innovation.
Absolutely. It's the means by which you are storing information, really giving your inventors a way of spilling ideas out onto the paper so that then that process can be reinforced over time, really getting innovation embedded into the business as a cultural setup, I'd say.
Okay, so why is invention capture? Why is it important for SMEs and maybe even sole inventors?
Okay, so it's really important for being able to make sure nothing's left behind. You know, for an SME who perhaps doesn't have the budget of a multinational, it's quite easy to forget what it is you're doing. You know, maybe you've been running hell for leather on a project that really needs all hands on deck, but the documentation hasn't happened. So getting a structured and rigorous mechanism for recording information, make sure that your SMEs or your individual working at pace actually has the information recorded to be assessed.
Okay, so I imagine this helps significantly with internal clarity. It's about knowing who contributed what, and when they contributed.
Exactly. You know, this all leads into inventorship. Who has done what? We need to know exactly who has made something in order for a patent to be filed.
Okay, so just diverting into that then. So explain why is inventorship important?
Okay, so an inventor is the person that comes up with the idea, and a group of people might be a collection of inventors. But from that grouping, from that set of people, that's where ownership comes. So the inventors are the original owners of the idea and therefore the patent application, unless there's something else that changes that. So contract of employment, maybe an assignment of rights to another organization. But it all flows from the guys doing the work in the first place.
Okay, so and is there any risk particularly with inventorship?
Yeah. So let's imagine a scenario where you've got maybe a contractor come into the business. They have done some work for you, but perhaps you haven't sorted out your IP contract completely. Well, you can imagine a scenario where you've filed your patent application for your brand new product. It's really going to lead the way in the market, but you've left off an important inventor from the contractor. Well, they could come and maybe apply for change of inventorship on the application. They could then apply for change of ownership. And that could happen during the life of the patent application. It could even happen after grant. So there are serious legal risks with getting inventorship wrong.
Gosh, so that's quite worrying. And what about these collaborations, particularly with maybe say universities? I mean, you touched on contractors there. Yeah. Are there any extra risks with that?
Yeah, look, Rob, collaborations can be dangerous. I said it. The thing about collaborations is because you've got multiple parties working together, maybe multiple inventors coming together, there's all sorts of cross-pollination between the parties who might want to own the IP rights. And in that scenario, Well, you can see that doesn't get sorted out at the beginning, runs all the way through, and suddenly there's a knot to unpick at the end. Maybe the university wants a share of the rights. Maybe you had a plan on keeping it all yourself from the beginning. So what I'd say there is make sure you split it out. You have those conversations early on, and actually invention capture, documenting all who's done what, who's contributed to a particular invention, can help with just unraveling some of the stickier positions that you might get yourself into.
Sure. So what are the common mistakes that you see when it comes to invention capture?
Yeah, look, it happens to everybody. I think one, delay. Failure to think about applying for a patent application early on. Maybe you get to the launch of a product and then bam, you're having to wait to actually launch before while the patent application is applied for. So that's a big problem. Number two is the reverse scenario. So let's say you've gone and maybe started telling people about your product a bit too early. Unintentional disclosure is an awful scenario to be in.
Sure.
So not filing your patent application or any sort of IP rights before telling on about it, terrible place to be. I think tying those two strands together, well, it's failure to seek guidance early on. Now that could be guidance for the R&D team, that could be guidance for the management team, but either way, you probably want an IP professional in early to look at the invention capture that you're doing and give you a bit of a steer on, is this commercially sensible to patent, or is this actually just a waste of time? You know, that's the value that patent attorneys can give.
Okay, so what you're really saying is it's about adding some commercial value, really, to the business. Looking at what your R&D team are doing, and then making something of that that's really pertinent.
Yeah. Look, the important thing is to make sure that the structures are in place within the business to assess whether or not particular ideas are being developed and are being protected in the right ways. You've got to have that commercial strategy in mind. It's got to be front and center, and everyone's got to be moving in the same direction.
Sure. And with that in mind, actually coming back to the disclosure point, that could be a really serious problem.
Yeah, you really don't want to be the one guy in the team who everyone's working in the same direction, but you've let the cat out the bag. Terrible position to be in. You might completely torpedo the launch of a product. It's not where you want to be. It's not where anyone wants to be.
No, I mean that could be devastating for the entire team, really, couldn't it?
Yeah, absolutely. You've got to think about the effect that might have on morale, and marketing teams often get a bad rap for that sort of thing. Well, look, let's ban things on Facebook, Twitter, or X, whatever it's called now. That's easily done, but the other thing to think about is AI. Most people are starting to use AI in some form in their business, and well, let's be frank, sometimes those can be non-confidential disclosures, and that could be management, that could be the development team themselves. They're probably the ones most likely to be working with those kind of tools. So it's anybody in the business. Everyone's got to have it in their minds that you keep things stumm.
Yeah, sure. So what does a good invention capture process look like for a small business?
Yeah, okay. So I've talked about rigidity there, and it's about setting up structures. So within the business, I'd probably say start having regular review meetings. And that again, it probably wants to be the development team with management, just getting together and saying, hey, what have we been working on? Where does it fit in with our commercial priorities? How can we move things forwards on an IP front? And how do you systematize it? Well, probably I'd say proper invention review forms. Keep those somewhere where your research team can get hold of them, can actually jot them down. Engineers like to write things down on paper these days. So give them paper, let them write it down, scan them in, get them reviewed. And that's the thing. It's all about review, making sure that the priorities are assessed by someone who can really steer you, making sure that you're spending your money in the right way as a small business.
Sure. And so what would you advise people to put in an invention disclosure form in their business? What would be useful information to capture?
Well, look, what goes into a patent is what we need to know about. You've got things like the title, the summary of what your invention is, the data, the drawings, all those are good stuff. But the two things that people tend to miss are, tell us about the problem you're actually trying to solve, because that gives us a steer. That's how we define inventiveness as patent attorneys, how the patent office are going to look at it. So tell us about that. But as much as anything else, tell us about what worked, what didn't, what alternatives you were thinking about. Because if we're going to craft something that's very broad, that's going to give you a decent scope of protection for whatever it is you're going to do over time, we've got to know about the things that failed, but also the way your competitors are going to make workarounds.
Sure. And so do you ever see cases where people assume that something just isn't worth protecting? They don't think they can get a patent, so they just don't come to us with it.
Sure. I mean, sometimes I'll tell people that you're not going to get a patent for this. It may not work, but that's the process to go through. It's ask someone who's been through that. Patents, they're not all designed to protect groundbreaking, bleeding edge technology. Sometimes it's about small, iterative improvements that maybe lead to an inventive step. And sometimes it's quite hard for people really working on the commercial side of things to see that. But if they have someone like ourselves look at the details on the invention capture form, fantastic. We can say, look, this is a probable win. This is a difficult one to get granted. Any of those things are possible. You can only make sensible decisions if you're fully informed.
Sure. And on the other side of that, then, you could have a new product, but it might have lots of other ideas thrown into it to make it successful. Yeah. So how do businesses navigate something like that, in a cost-effective way?
Yeah, cost-effective is absolutely right, Rob. You really don't want to file 5, 10, 20 patents for what might be a relatively small product, but which has lots of fun bits attached to it. So what I'd say is try and get a patent application filed. Look, we can write about all the different bits and pieces. We can feed them in. We'll focus on the core inventive concept. That's what we do. But so long as we've been told about what all those different things are, we can bake into the patent application, into the disclosure, all of the avenues that you might want to explore over time. And then look, we can file divisional applications to our heart's content in the future.
Okay, so just tell us a little bit about divisional applications.
Oh, divisionals, yeah, sure. That's think about clones. That's a mechanism by which you split your patent application up into maybe multiple different ones, but all stemming from the same original date. So you don't need to worry about intermediate disclosures. You've maybe put something on the internet that's going to kill that later one. No, it all stems from patent application number 1. So what we can do is we can split it in 2, use the same disclosure that we had from day 1, and just change the scope of protection that we're looking for in the claims. And that means that maybe invention number 1 can run straight through to grant the patent office, but invention number 2, we can just sidestep and run it along separately on the same course, which then gives you a nice portfolio.
Of course. And so SMEs should really, they need to think about the strategic value of invention capture, because having more than one patent can actually be really great, can't it?
Yeah, absolutely. But we mustn't just get focused on patents here. It's great to have a patent portfolio, but it's also great to have a portfolio of trademark rights. It's great to have a portfolio of design rights. All of those things give complementary protection to a product or product range. So invention capture can help feed those sorts of things in, making sure that you've got that holistic view of the business and where the strategy ought to go.
Yes. So really, you just don't want to leave anything on the table.
No, absolutely not. Just keep in mind the commercial goals that you're aiming for and work on that basis.
Okay. So you need really good joined up thinking. And really, if you had one piece of good advice for an SME founder or even a sole inventor watching this, what would it be?
Yeah, it's culture, Rob. I think just make sure that you foster a sense of innovation culture within the business. Get your research guys on board, put the forms in front of them, let them loose, because that will result in important, relevant information being committed to paper, great. You can make assessments on your business.
Super. Thank you for sharing your insights today, Will. If you're watching this and wondering whether your idea is worth capturing, we encourage you to seek early advice. It could make all the difference. I hope that you've enjoyed listening to Figure 1, an IP conversation brought to you by Albright IP. I look forward to you joining us next time.